So when the opportunity came back, I think the discussion started back in, quite frankly, in the 90s, 96, 97, 98. At that time, I felt I didn't want to get appointed to the bench right away because I was enjoying my law practice. I figured, well, let me enjoy my law practice. I don't want to be a judge at this stage. But I was doing my own homework. I looked for a person that I felt would make a difference in the Cree court. I found that person in the likes of Don Bird. Don Bird was an RCMP and a member of Montreal Lake First Nation who grew up in La Ronge. He understood the enforcement aspect. He understood the issues confronting people within a poverty situation. He understood the issues that are facing young people because of his work within child advocacy. And he had done his articles with the Department of Justice. That was back in 99 when I had that discussion with Don Bird, 98, 99. And he agreed, but notice I didn't get appointed until 2001 because I kept staying away from it, making sure the homework, to try and find somebody to deal with and work within legal aid. Well, as we all know, when you have a new influx of people within the legal system, they will branch out and they'll make their way and they'll do good work and they'll be in high demand. Working for legal aid might not be the most attractive for a lot of our young Aboriginal lawyers. So it becomes a little tougher to find somebody within that framework. But I think things will change there too. We are having more people who are committed and seeing that perhaps they can help in that particular process. Now, when I deal with people in Cree court, I think sometimes people make a bit of a mistake in saying that just because I'm an Aboriginal person, I will go softer on my own. That's not necessarily true. But it depends how you define how hard I am on somebody. That 10-minute discussion I have with somebody, I always say when they're represented, can I address your client in Cree? I've not been refused yet. One of these days I will, I'm sure, if the lawyer knows what I'm talking about. But I'm asking a lot of questions. I'm asking a lot of questions to that person who's in front of me because I want to know more. So that what I do reflects who is in front of me. And as Joey Swan always says, use the voice, he says to me. He says, we want you to talk to this young person and use the voice. I said, Joey, get out of here. But the discussion that I have with that person in our own language, of drawing from them, understanding what they have done. And I will use issues. I'll give you an example, a small example. But a person is arrested, okay? He's arrested, he's intoxicated, then he resists arrest. He starts punching, he starts swearing, he starts calling down the police. And they will use derogatory language against the police. White pigs, etc., etc. Okay, so how do I deal with it? I deal with the issue of respect. I deal with the issue of self-respect and say, how do you begin to respect somebody if you don't respect yourself? And how do you learn And how are you going to change that policeman's attitude if you don't respect him as a human being? As a human being. Because a policeman's job is not easy. And I will deal with issues of the protocols of what levels of force have been looked at. And believe me, I learn every day what those are because I listen carefully. The other day I heard one description of an arrest process where it said, hard hand takedown. I said, what's hard hand takedown? Well, the policeman uses that in his description to guilty. I said, excuse me, officer, what's hard hand takedown? Well, he says it can be a punch, it can be a takedown by the arm, it can be different levels of force. I said, okay. But it's a key word. Now, that's a bit of a lesson to the rest of the audience that were there. I certainly didn't know what he was talking about. But you begin to have them explain what they do, what their protocols are, what they understand, the level of force they can use within that given situation. When a person is in front of me and says, I don't remember what happened, then it's a little tough, isn't it? To say it didn't happen if you can't remember. One side remembers, you don't. So what are we dealing with? We've got to do something with respect to your addiction that makes you forget about this stuff. How do we deal with that? But also understand what the responsibilities are of the policeman. I will explain the different protocols, and I will explain that the discretion rides with the officers. I'm not an apologist for the police, but I don't mind explaining those type of things, because part of the legal education that has to occur within that given time and space of who is in front of me. And still deal with it on a basis of respect. Those concepts go both ways. So I think sometimes the lawyers are not sure when we have those hard discussions. And because of my voice and the way I talk, perhaps he's thinking I'm giving heck to his client. Well, it's not necessarily so. I just happen to have a big mouth and a loud voice. That's beside the point. Now, Judge Lafon alluded to some of the things that we require in what we do. Now, certainly, the number of inquiries or a number of coroner inquests that have occurred in Saskatoon and elsewhere. I remember doing one even in Wollaston Lake, where a person had committed suicide within that community in jail. What are we doing? Now, there's some movement, of course, to look at people that are picked up for intoxication to take them to detox centers. But how long of a stay will that be, and what kind of follow-up occurs? Because if we're not dealing with a criminal activity, but merely a mere showing of a person's addiction out in the open, then how do we deal with that? We can sentence people to jail in large numbers. Nobody will ever stop us in terms of doing that. When I say nobody will stop us, not there, they might in terms of appeal, but they don't tell, government doesn't tell you can't do that. But you try and sentence one directly to a rehab center, and they say you cannot do that. Well, the principle behind that, of course, is we can't make government spend money in a particular way. Well, part of it stems also from the characterization of those facilities. The characterization of those facilities is one's a correctional center, one's a rehab center, and until it becomes a correctional center, you can't sentence to it. So characterization of the facility itself makes a difference. And it is a bit of a misnomer in a certain way, because if I want to dry out somebody, I can still give him 30 days. But yet he doesn't get any treatment in that facility, and he would in this other facility. So why am I stopping doing it? It's a characterization of where I can send people. There may be a greater need for the treatment of that person. But yet, we're not allowed. The closest thing we have, of course, is treatment facility, like the St. Louis treatment facility for impaired drivers, which lasts 14 or 21 days for that type of treatment. Most people that I have talked to over the years on the issue of drying out will say they've been in probably 10 to 12 facilities over the past number of years before they ever got to where they are. That's 10 to 12 times they've been trying to go to a treatment center in order to fully learn what it is that they needed to learn and have the self-confidence and feel that they can do something about those type of addictions.